Well, thanks for coming to listen to the Prohibition on the Purchase of Residential Property by Non-Canadians Act review. For those who had attended the webinar, you'll note that this probably feels a little bit different from how I presented the first time, largely because I forgot to press the record button when I first did the presentation. So this will be a second version of that same presentation, maybe a little more succinct at points. The point of this presentation is just to go through this piece of legislation and some of the regulations that had given effect, so that people within the industry have an understanding and appreciation of what the obligations are around it and what some of those restrictions are. So as we go through it, you'll see a couple of things. One, we're going to review the background and the purpose of the Act very succinctly, just in terms of what's been publicly available. We'll discuss what is a non-Canadian under the Act and which non-Canadians are also exempt from the Act and thus able to buy residential real estate. We will talk about what a purchase is. We'll talk about what a property is considered exempt from the Act and what some of the implications are associated with breaching that Act. Now, in the background, the Act, I think, was part of the Budget Implementation Act back in probably March or April of 2022. There was a piece in there that dealt with how the government of Canada wanted to pass a new law in order to help make homes more affordable for people living in Canada. The concern was that especially in some of the hotter metropolitan markets, that non-Canadians were coming in to purchase property and driving up the pricing associated with some of those properties and leaving them there largely to remain unused, and so solely as kind of an investment vehicle. People who they weren't even being used as rentals at times, and that was the concern, and that's being addressed by other forms of taxation, I think, that were coming out in Ontario in particular, dealing with vacant properties. But this was kind of one extra piece to it, and that was to prevent non-Canadians, as defined by the Act, and corporations and other entities from purchasing residential property in Canada. And the intention was to have this occur for a period of 2 years. Although that time frame is not expressly provided in the Act, it was clearly part of the underlying policy statement of what this was supposed to be. And so the intention supposedly is to remove this restriction after 2 years' time. I just note the minister responsible for the Act was the Minister of Housing, Diversity and Inclusion, noted there. I just thought it was kind of a funny note that it seems very non-inclusive to then restrict a bunch of non-Canadians from being able to buy residential property in the country. But so be it. Criticism of the Act, a couple of things. So it's not going to be effective at changing the available supply of real property. I've seen that criticism kind of throughout a number of different commentary pieces that I've seen, that, you know, again, it's not that they can't own property right now, it's that they can't purchase it. So it's really going to be dealing with those situations where people would be coming into the marketplace in order to use it solely as an investment property. There is some concerns about whether this creates an unfair administrative burden or liability on professionals working with home buyers. You know, the legislation talks to a standard of knowingly assists, but I think that as part of that, there's going to be an obligation of some base level of due diligence to ensure that you're aware of the restrictions under the Act and whether or not your clients meet those restrictions. And then the other kind of more interesting commentary was if this is going to create some challenges for some skilled foreign workers, making Canada less attractive as a final destination for relocation purposes. Because as you'll see, someone who comes under a work permit who is here for a period of time has to kind of work for, I think, 3 out of 4 years on a what's called a full-time basis in order to file tax returns and all those things in order to meet the requirements of this Act and not be considered non-Canadian. So if you're moving to Canada to work as kind of a skilled professional, you are only able to rent for a period of time. You can't purchase properties right away under that visa. So Very simply, the purpose of the act, like I said, to prohibit non-Canadians to purchase directly or indirectly any residential property. We'll deal with kind of each of those elements as we go through the presentation. What is a non-Canadian? What it means to purchase directly or indirectly? And what is residential property as defined by the act? A non-Canadian, very simply, is an individual who is a Canadian citizen. Two, a person registered as an Indian under the Indian Act, or a permanent resident as defined by the immigration legislation here in Canada. The short form is IRPA, IRPA, the Immigration Refugee Protection Act, or something to that effect. It also, we'll see both through the act and the regulations, impacts a corporation or an entity being kind of a broader term to denote any other kind of business association that can, like a partnership, that wouldn't be technically a corporation, that is either incorporated or established otherwise than under the laws of Canada or in a province, or alternatively incorporated or established in Canadian or provincial law, but controlled by non-Canadians. And we'll see that kind of description down here. Control is a very restricted piece of this legislation. So it indicates that the non-Canadian owns either 3% of value or 3% of voting rights, or they describe it as control in fact, which just basically means that through a management agreement or otherwise that they're in control of the corporation. And so through that, if they are in control, then that corporation or entity is restricted from buying residential property under the description of the act. This is kind of the list of how they describe the more formal definition. So the one kind of commentary on here is that there is some leeway for corporations that are listed on a stock exchange. In particular, there is some language around that as well. Exempt non-Canadians. So you'll see kind of a few different groupings of people. So kind of the most, probably the least likely to impact everyone is going to be the foreign state or the consular official piece, at least in Saskatchewan. That's just saying that if, specific consular officials or otherwise come to Canada, despite the fact that they would be considered non-Canadians, they would not be impacted by this piece of legislation, and they could purchase property and the like. And that's just kind of as part of the diplomatic ties portion of Canada and inviting these individuals to our country. They also have kind of a whole segment dealing with temporary residents fleeing conflict or recognized refugees. So the refugee piece, I think, is going to be is something that I can't say with any certainty that I've got a lot of clarity on. There's steps in the process of being considered an eligible refugee under the IRPA, and so if you were dealing with someone who is kind of classified in that segment, you should probably get them to get independent legal advice as to where they're at in that process and whether they qualify for purchase of property by virtue of that. I think the more expansive portion of this would be the temporary resident stuff. So there is two classifications of temporary residents, both kind of a student portion and a worker portion that describes some conditions that you've got to meet in order to be able to purchase property. The part that I'm not certain about, or that I'd like more clarity on, is the temporary resident fleeing conflict. So a lot of the Ukrainian, those displaced by the Ukrainian conflict, currently I'm not clear from my review of the legislation as to whether or not that's who's contemplated by this. It was a kind of a piece as part of the regulations that was just released in December. It seems from a timing perspective that would make some sense that that's who they're intending. I'm just not clear as to whether or not they've taken the steps necessary in order to get to that point in particular. So it'll be interesting to see if there is either blanket authorization, or if maybe it's just individual to someone specifically that they have to get confirmation that they meet that threshold in order to be able to purchase property. The temporary resident piece you'll see down here. So if you're a student, there's certain kind of restrictions. So you have to be in a program authorized by the immigration legislation. You have to have filed a tax return for 5 years in the preceding the year of purchase. So filed for 22, 21, 2019, and 18. If you're buying this year, you have to be present in Canada for 244 days in the year in each of those 5 years. You have to buy something that does not exceed $500,000 worth of value, and you cannot own more than one residential property. For a worker, so someone who's here on a temporary working permit, you have to be worked full-time for 3 of the 4 preceding years. From some comments when I first did this presentation, it sounds like that's a 30-year time frame. I haven't investigated that yet, but that wouldn't be surprising for me that that's the case. That they would have filed income tax in 3 of the past 4 years, and that there is no more than, again, 1 residential property for that worker. Also, if you are non-Canadian, but you're buying with your spouse or common law partner who is considered not a non-Canadian, so a Canadian or a citizen, et cetera, then you are exempt from the Act as long as you're purchasing with them. Important to note on this, common law has a different meaning than many other types of legislation, or it has a different meaning depending on the legislation that you're dealing with. In this one, it's a period of living together in a conjugal relationship, having so cohabited for a period of at least 1 year. So that's different than Saskatchewan's family property legislation. Here, it's living usually as 2 years for as spouses for that legislation to kick in. So that is a little more open in terms of what that looks like. When considering what a purchase is, I think most commonly people would like the most common understanding of what a purchase is when you buy a property under an offer to purchase would meet that requirement. I think it's probably more important to consider what a purchase is not. So things like the acquisition by an individual of interest in real estate resulting from death, divorce, separation, or gift. So if you're gifted this stuff, I think the separation and divorce piece is kind of interesting because often we're asked as part of a transaction to do an offer to purchase from the one spouse from the other spouse in order to kind of complement the refinancing obligations that come along with it. And I mean, that might require some specific drafting just to make sure that it's clear that it's not a purchase as defined by Section 4 of the Act. Similarly, if it's a rental, that's pretty self-explanatory. If you're getting transferred the property under the terms of the trust that was created prior to coming into force legislation, so that's probably a little more complex than what this webinar is about. But if there was a trust and you were being transferred property, that wouldn't be part of it. Or similarly, if you're receiving the transfer as a result of the exercise of security interest. So if a non-Canadian owned a mortgage that was registered against the property, went through a foreclosure process, and then was receiving the property through the foreclosure, then it would not be considered a purchase as per the Act. Also important to note a couple of things around what the residential property is. So it's not, I mean, the 2 kind of first bullets there, a detached home or building with not more than 3 units. So larger apartment complexes wouldn't fit under that if you're purchasing the entirety of the complex, plus land reasonably necessary for the use. So like acreages would fit under that definition. A townhouse or apartment condo or a townhouse that stands alone with kind of shared units, as long as you're intending to buy kind of the individual units by themselves, that would be considered residential property. And then land that does not have a dwelling but is zoned for residential or mixed use. So again, if you buy a lot and you hope that you can build a house on the lot, that would not be considered, that is considered residential property. So you can't get around it by buying a lot because there isn't a home on it and then building a home on it. That would still be considered residential property. Also, as a note, there was a section in the Act that talks about the Act doesn't apply if non-Canadians become liable or assume liability under an agreement for purchase and sale that came into effect the day before the act comes into force. This would be for something where like someone had pre-purchased a new home that's happening in April of 2023, but it was dealt with back in October of 2022. That is still okay. I think the open question whether or not there's any conditions that still exist with that offer to purchase. I'd probably get you to get independent legal advice. You'd be way safer to not have those conditions in place kind of after January 2023, so that you were not to say that you didn't assume liability after that time frame associated with when the act came into force. Property exempt from the act. So this is kind of an interesting and confusing part of the legislation. StatsCan puts out a concept called a census agglomeration or a census metropolitan area, a CA or a CMA. And it's complicated, but basically it deals with kind of if you've got 10,000 people within a certain space, or 100,000 people for the CMA kind of within a certain space. And that's how they're defining whether or not you're considered residential property. So even though you may be in kind of a smaller center, but you are within that larger CMA, you would be considered part of that. I pulled the list off of I think both of the StatsCan website and maybe the SRA that had created a list of potential small communities around Regina, and the ones listed in the presentation are those that are included in it. I will include underneath this presentation a link to what I found from the CMHC that describes some of the different requirements for the communities that are found within this. And if you're within this, then you are considered residential property. You cannot allow non-Canadians to purchase it. Also, I mean, this seems self-evident, but I'm going to say it anyway. This doesn't impact commercial or industrial properties. It doesn't impact kind of mid or large scale residential projects. So like an eight unit complex in the middle of the city as an investment property, non-Canadian can still technically purchase, but it would be the smaller mixed use stuff with like 2 units and maybe a commercial space. That's where you'd want to run into some protection associated with that. This is the CMHC website segment that I was talking about. There's kind of some specific maps that are included. I'll include these links, and this is just kind of the highlighting that I got from it. This noted on the left-hand side, the different CAs or CMAs in the province, and then with a little more detail, kind of some of the areas that come along with that. So just to be aware of that. The implication for breaching the legislation, pretty simple, that every Canadian, non-Canadian that contravenes Section 4 is guilty of an offence and liable in summary conviction of a fine of not more than $10,000. For corporations that engage in this or other entities, it can be directors, officers, management, supervisors that are all party to the offence under Section 2 of the Act. So yes, you can get a fine of up to $10,000 if you mess this up. I think the interesting piece on it, again, it's not clear from like the legislation. I'll go back to this actually. Talks about knowing that the non-Canadian is prohibited from this act of purchasing it. So I think there's kind of an obligation either to be aware of it or to be reckless as to whether or not you had knowledge of it. So I think you have to do some base level of due diligence to confirm that someone is not impacted by this piece of legislation, or at least that would be my recommendation to you. So that's that part. The interesting piece from the legislation, though, is that this doesn't impact the validity of the transaction. So as a buyer, as a seller, you don't have to be worried that all of a sudden 6 months down the road, Government of Canada is going to force you to rebuy the property. The transaction continues to have legal effect. What they can do, though, is A, find kind of the relevant parties, but B, they can also force the properties to be sold. So if the non-Canadian continues to own the property in contravention of that section and is charged and convicted, the Court of King's Bench can order the property to be sold, and then from those proceeds get all the fine and enforcement costs, and then payment to all other non-Canadians that have a claim against this and kind of in determination of their priority. So mainly lenders. They note then that the repayment to the non-Canadian amount that is not greater than the purchase price that they paid for the residential property. I thought that was kind of a funny way of putting it. I suspect that the intention behind this legislation was that if you only have a $10,000 fine, it still may be a good, cost of doing business to come in, purchase property, be responsible for that $10,000 fine. But then if you make $100,000 on the residential property that you purchased, then the $10,000 is just the cost of doing business. They say as part of this that the repayment to the non-Canadian is not greater than the purchase price that they received for the residential property. I would expect that that was intended to mean the equity, not the purchase price, because if you were paying out a lender already under the second subsection, then for the purchaser to have access to the full purchase price would allow for some of that that increase in equity above and beyond the amount that they received. Maybe the repayment language in that section, but I mean, neither here nor there. It's just funny in terms of how I would have worded that. My big questions that remain, a couple of things. Immigration, so specifically that those would be displaced by Ukrainian conflict. I think they'll have a number of those throughout Canada, and potentially in a position to purchase property. If they are able to is kind of unclear to me by virtue of the act that, or the order that allowed them to come into the country in the first place. Enforcement of fines and penalties, kind of what that's going to look like, who's going to be responsible, how that's going to all play itself out, what the standard of due diligence is that is necessary for the parties that participate in this. There's also a section in the regulation, Section 8 of the regulations, that talks about Aboriginal rights per the Constitution Act 1982. The regulations state to the extent that they may be in conflict with that section, so any Aboriginal rights that might be within those CAs or CMAs, that the act does not apply. So I guess it's an interesting, lease properties within the CMA or CA that maybe otherwise be impacted by this could be exempt by virtue of that section. That is it. In terms of the questions that were raised, there was some questions around that control piece and just the clarity around the control piece. So yeah, it's quite cumbersome. I mean, if 3% is either owned or the value of the property is owned by kind of a non-Canadian, or effectively they're managing or controlling the corporation, that would have a very real impact on that corporation's ability to purchase property. So pay particular attention to that. And I think, again, there were some questions about immigration. Again, it's just outside of the confines of what I'm able to do. If you find yourself dealing with a temporary resident or a refugee or someone who is displaced from the Ukraine, you probably get them to seek out independent advice on that point first before you participate in some of the home buying process. Just should not waste their time or your time, or to obviously bring yourself to the point of being exposed to some of these fines. That's it. If you've got any questions, feel free to reach out to me directly. But yeah, otherwise, best of luck. Thanks.